Hello and welcome again to Immigration News and Views. My name is David Nachman, and Felicia Zeidman, my colleague, is here with me today, and we have some late-breaking news that we'd like to share with you. Before I do that, I just want to let you know that the Nachman Pawani Zimochek law firm is located in the state of New Jersey. We also have offices in Midtown Manhattan and affiliated offices in Canada. And Felicia is a Canadian immigration practitioner as well as a U.S. practitioner. And we also have an office, an affiliated office in Mumbai, India, which incidentally I'm going to be visiting very, very shortly. I'm going to be traveling to India. And actually that is some of the late-breaking news, has to do with an Indian company that recently has been under the microscope and scrutinized tremendously by some of the administrative agencies here in the United States with regard to their hiring practices in the H-1B and B-1 arena. So with that, maybe Felicia, you can give us a little backgrounder on Infosys and what's going on so that we can share this information with our viewers.
Thanks, David. This company has been growing exponentially for many years. Extremely successful business both in India and the US. And of course in the United States they have to abide by American immigration and Department of Labor regulations as to how people have to be hired and monitored. And the American labor system has requirements for American workers to have I-9s. Anybody working in the United States, excuse me, not American workers, anybody working in the United States has to have an I-9 form filled out for them. The I-9 form regime, as you will know if you've been watching a number of our videos in this package, requires that the individual be authorized to work in the United States, and it's a pretty lengthy form, and it carries fines of up to $1,100, $1,200 per person if it's not filled out correctly.
Per form.
Per form.
Yeah,
per form, per person, per form.
Correct. Mm-hmm.
So it can turn into massive fines, which appears to be what happened at Infosys with their $34 million fine. Now,
we'll say that again. I think our viewers need to hear that because that is the largest immigration fine ever. I think that that's only rivaled by well, the second largest, I believe, was a $12 million fine against Walmart back a couple of years, and that had to do with a very interesting situation where what they were trying to do, and actually what Walmart did is entered, and by the way, this was a settlement. So the settlement is that Infosys is going to be paying the federal government $34 million, as Walmart did. Walmart paid the federal government $12 million, and that was also an I-9 issue. And back when that happened, what happened there was that there were some people who were working on site at Walmart, and the managers at Walmart realized that these people were not authorized to work, sent them away to get hired by a staffing agency, and then brought them back in as independent contractors from that staffing agency. Now the thing there is that the managers knew what was going on, and that was very egregious, which is why, of course, those administrative agencies, the U.S. Department of Justice and ICE, went after them with such a vengeance. Now in this case, there's also a bit of egregiousness that went on, or at least that is the allegation. So the egregiousness in this case is that the managers were telling the employees how to circumvent the rules. Now, this is really the big issue in the case, and I'm not saying whether it's right or wrong, because, and what we're going to do is point out the gray area for, for our viewers. But, I think that what we're saying here, and what Felicia is driving home for you, is that, number one, have your documents together and make sure you do self-audits, and make sure you do your I-9s, but also don't engage in egregious behavior that could potentially risk your being fined or coming under investigation by these agencies.
I mean, it is important for companies to investigate what's the best way to bring workers to the United States. What's the most cost-effective, what's the most efficient, what's going to bring in the best workers, and how many do you need, etc. These questions have to be asked by companies, but the work that can't be done, willy-nilly. It has to be done in a very, very careful way. And the massive amount of this fine is really to say, that Big Brother is watching you, for lack of a better term. That there are all sorts of agencies watching companies today, and it would actually the amount of the fine to Infosys it must have been much higher than 34 million because that's just the settlement number.
Exactly.
So the amount of the fine is an indication that they were behaving really in a way that was not attentive to the regulators' requirements. It is important to pay attention to those rules. I mean, there is somebody watching this stuff out there, and we've seen it time and time again because we deal with I-9 violations and intent to fine and audits all the time. We know that there are agencies that are, out there looking at the field and trying to figure out where violations may be occurring. Now, to speak specifically about what happened with Infosys, it was the use of B-1 visas, which are visitors for business, as a replacement for what should have been H-1Bs.
Right, now, and this is the allegation. The allegation is the use of B-1s, and what it is that a B-1 is an individual who's coming, I'm just going to give the background.
Please.
The B-1, we've done a couple of videos on this, but the B-1 is a business visitor. It's an individual who goes to the U.S. consulate and gets a B-1 stamp, and they don't have to go through the H-1B process, which of course everyone knows is very time-consuming and very costly. And you have to initiate that process here, and what you do is you then have that visa sent over to, let's say, India, if that's where the employee is coming from, and Infosys, of course, is an Indian public corporation, and so that's where most of those employees would be coming from. So rather than to have to go through the whole H-1B process, where the H-1 is initiated here and then sent to the U.S. consulate abroad, in the case of Infosys, what's going on is that the individuals are walking in and saying that they're business visitors and that they're coming to the United States to perform services in the U.S. on behalf of the foreign corporation, which is not an impermissible thing to do under the regulations. The Foreign Affairs Manual does specifically have a carve-out for B-1s that says that individuals can come for and on behalf of foreign organizations to perform services in the United States on behalf of those foreign organizations, as long as they're not being remunerated in the United States, and they are doing it for things that are considered to be international in scope, and also, and this is really the kicker, and that they are not displacing U.S. workers. So that really is the crux of the matter, is that the allegation must have been that they were doing something to displace U.S. workers. Now, from what the media seems to be reporting, is that the managers were providing the employees up front with information about how to sidestep the possibility of an allegation that they are quote-unquote working in the U.S. as opposed to performing services on behalf of the foreign corporation.
I think just to reiterate what David's saying, a business visitor will come to the United States to cultivate business, to have meetings, to basically sit at a table and talk to their counterparts, to try and discuss different ways of doing business and how, let's say, Infosys India could provide services to various people in the United States. Whereas an H-1B or any worker has his hands out of his pockets, is sitting at a computer terminal doing programming, for example. In this case, it's kind of easy to envision that sort of thing, is working with hardware and trying to build something, and actually doing work as we understand work to be for the American corporation here. It would appear that Infosys has a tremendous number of people coming over from India to work here. Why are they doing that? Why aren't they hiring Americans? So the allegation in the media is that they're able to get Indian workers to work for less money. This is an interesting allegation because H-1Bs also protect wages.
That's correct. The LCA, as everyone knows, our viewers know that we've presented videos on the labor condition application and how the labor condition application is a federally mandated prevailing wage that's generated through the ICERT program.
So in that way, the H-1B program protects wages and ensures that a company cannot hire staff who are going to undercut the wages. But there's no such wage requirement, of course, on a B-1,
Exactly.
Since there's no expectation that the person is going to be doing work.
Exactly.
So the wage issue is just, it becomes a free-for-all. So a lot of people are very angry at Infosys for proceeding in this way and in their minds displacing American workers. And I think that this argument is only going to become stronger over time. We are in a time when protectionism of the American worker is a natural thing to feel because of the ongoing struggles with the labor market and recession effects. Especially effects on people who are highly educated and highly skilled and can't get jobs.
Let's talk about fallout. So what is the fallout from a case like Infosys? What do we see? I think one of the major fallout situations is the possibility of what's called whistleblowing. And we have an individual who actually was a US worker who still is employed by Infosys. He was given a position there and he's still being paid, but he's not being given any work. He was a lawyer in the company who actually blew the whistle on Infosys because of what they were doing, and that was, in his mind, they were sidestepping the rules. So he reported that.
Well, I think they asked him to prepare documents that
right.
that he saw as blatantly sidestepping the rules.
Correct, exactly. And it's not unlike what we saw in the labor certification context many years ago, where individuals, actually law firms, had allegedly prepared memoranda that they were giving to employers to tell them how to go about the recruitment process in the labor certification process, and there were things put into that memorandum which led, unfortunately, led to an unreasonable thinking process within the realm of those protocols, and that was actually with regard to Siemens. So this is the kind of thing that, and that was also a whistleblower case where it was an individual down in Florida who blew the whistle on Siemens. So I think whistleblowing is certainly one thing that's going to continue to go on. Another thing with regard to fallout is, what is the effect on what's called the B-1 in lieu of the H-1B? There's something called the B-1 in lieu of H-1B where individuals can go into the US consulates and use the B-1 in lieu of an H-1B. Obviously, a B-1 in lieu of an H-1B is going to come under a tremendous amount of scrutiny. Now, in fact, what's probably going to end up happening is that they're not going to be able to utilize the B-1 in lieu of H-1B. So that's almost going to be a category that's going to completely go out the window altogether. So that's another piece of fallout, if you will. Another piece of fallout, another thing that we're going to see that's likely to happen, and I think we're seeing it now, is with regard to comprehensive immigration reform. What's happening is there's tremendous discussion now about coming down on H-1B and L-1B companies.
There was already a lot of pressure on that before the Infosys arrangement.
That's exactly right.
So this just adds fuel to the fire about protecting workers as part of comprehensive immigration reform.
Exactly.
So we can expect, I think, that the I-9 regime is going to grow in stature, grow in importance,
Absolutely.
that these fines of $1,200 per misused form or per person are not going to go down.
Right, and let me make clear the segue into the I-9 procedure.
Please.
Is that ordinarily, if you have an H-1B, they would have to do I-9s, where if you have a B-1 who is on your staff, that's an individual who's a contractor, they are exempt from doing the I-9s. So here what we have is we have putative employees, which is why, unfortunately, and that's what maybe the allegation is that they should have been doing I-9s. These are B-1s, in this case, at least allegedly, are putative employees and should have been doing their I-9s.
I think that about summarizes where we're at. I expect that more details about the Infosys judgment or settlement, will come out, and I hope to be back in this forum to discuss them.
Thank you very much for your time, for tuning in, and we look forward to bringing you this cutting-edge information with regard to Infosys, the settlement, and what the potential impact will be for you, your staff, your organizations in the future. Thanks very much for tuning in.
Have a good day.